The random people popping in and out, I think those are mostly ISN staff at this point, except Barry had said he thinks he's going to have one more person jump on, but we can always go back to them. Todd is working on getting us recording, actually, because
we are.
It was going. Okay, you're good? Okay, good. We are now recording. So, Joel, I think I had said this before you hopped on. I'm recording today's session, so if there's anything, if you want to bow out, now is your option to do so. All right, let's hop over then to our guests. We'll start with David, and I don't know if you want to just introduce yourselves and then go back to your presentation. Sure. Cool.
So I'm David Weller. I'm an attorney and partner with Boardman and Clark, and have been counsel to ISN for the last couple of years as well, and assisted with a number of charter school implementation and going into actual charter schools, actually operating. And Tess is to my left.
I'm Tess O'Brien, and I am an attorney at Boardman and Clark also, and I have advised many charter schools actually on kind of the whole phase of things, all the way from the charter contracts to governance board issues, becoming non-stocks, 501c3s. I've facilitated things that have happened between school boards and charter schools, and gotten all the way down to potentially revocation. And didn't get that far, thankfully. But so I've kind of seen the whole gamut from the start to the finish.
And I'm Rick Verstegen. I'm an attorney with Boardman and Clark as well. I've been with Boardman and Clark for the last 12 years, maybe. But my work primarily is with school districts, but I sometimes assist Tess and Dave on different issues that prop up with charter schools, which could be labor and employment issues or governance issues, open records, meeting issues, things of that nature. So.
Okay, well, I'm going to start, and we'll start with charter school governance. And Sarah, are the outlines up and available?
I am sending them as we speak.
So I'm going to try and follow
in the inbox.
Follow my outline as best I can. And so we've seen a recent explosion, I'd say, in charter schools in the last 5 years or so. And as you know, a lot of that I think is due to the federal grants that were out there that many of you have participated in. And charter school being just another tool for teaching students. When we're talking about the governance of the charter school, we've got to remember what the structure is. So as the individuals on the call today, generally we've got articles of incorporation, we're going to have bylaws, and we're normally going to be very interested in getting some sort of tax exempt status, generally through an application to the IRS on what is a Form 1023. And those really become your basic documents for structure. In general, we are then, as a charter school, normally a non-stock corporation. That's a corporation under 181 of Wisconsin statutes. And so that's going to set our structure. In general, all power is going to come from the board. So the board's in control. The board of the charter school is in control. And then the board can delegate if the board wants to. So the board can delegate whatever it likes. The articles of incorporation might delegate some things. The bylaws might delegate, and then the board itself could vote to delegate some power to different organizations or different committees or whatever. Generally, you've got to be an individual if you're going to be a director. So as you're looking for directors, you need individuals to fill those spots. You could have, and you might want to have, a corporation in certain charter schools where a corporation is very closely tied with that organization because that corporation may be providing some funding. So what you could do, because you can't have a corporation on the board, you could simply have a board placed. If you've got a situation like that where that corporation may nominate somebody, a person, to be on the board, but we can't have a corporation on the board. The members of the board don't have to be Wisconsin residents, and they don't have to be members of the corporation. Generally, we're going to recommend that you not have members of your non-stock corporation. What's a member? So a member if you think of a for-profit corporation, generally you're going to have shareholders. In a non-stock corporation, you don't have shareholders, but you could have members, and your articles would tell you who becomes a member and how. We're generally going to recommend that you not empower this group of people to essentially elect board members when you probably want to keep the power within the board and allow people to come up through the board. It's a concern, I think, at the school district level of losing control of what is the charter school. So if you think about that, there's also a requirement for a number of directors, and you're going to have more than 3 anyway, but the legal requirement is that you have at least 3. To elect the directors, you're generally going to have your directors elect the future directors because you won't have members. So in general, you're going to have whoever's on the board at the time is going to elect that next slate of directors. Often you're going to want staggered terms so everyone doesn't come up at the same time for election. And if you've got a 9-person board, one way, if you can talk people into 3-year terms, which may seem really long, but if you can do that, it's really nice to be able to just have 3 people or 3 seats come up every year. That way you're going to have continuity. You're not going to lose experience and knowledge and have a full turnover of the board, which could mean that you don't get much done for 6 months. Generally, the term is going to be specified in the articles. If for some reason it's not, it's an annual term. Now, your board members can resign, and they would resign by delivering written notice to the board. It's going to be effective when they make that resignation, when they turn that resignation in, or at some later date if that's specified. By the same token, a director could be removed. And unless your corporate documents, and when I say corporate documents, I'm talking about the articles or the bylaws, unless those documents say what the vote is to remove a director or what the process is, it's simply a vote at a director meeting where you've got the same, generally majority, you've got the same requirement of a vote to elect that director, whatever that happens to be. Now, in general, you're going to have regular and special meetings. Your regular meetings will just be laid out in the bylaws, telling you where, when, what time, and how often, whether that's monthly or quarterly or whatever. But to the extent you need to meet again and you can't wait for the next meeting, that would be a special meeting. And so you can have meetings like we're having today without actually getting together. So you can have a meeting anytime that all of the directors can hear each other, can speak to each other, and can respond at the same time. So you can do meetings by phone. If that's convenient, you can do meetings by, like we're doing through the web, or you can do a meeting, maybe technically you could possibly do one through almost like a group email, as long as everybody's responding to everybody at the same time. Everyone's got to be able to hear everybody or see what's being said, and back and forth.
Am I allowed to ask questions in the middle?
Absolutely.
I had heard that.
And I should say, so that doesn't just go for Sarah.
Oh,
that goes
okay.
for everyone.
Special privileges because I showed up. I had heard that you can't do group emails because they're like walking quorums. And maybe you'll get into that more. And then I had also heard that traditional school boards can't do virtual meeting, like virtual attendance. They have to be in person, but a charter board can do virtual or telepresence.
Yeah, well, and I don't get into general school board meetings.
Oh,
I'll let
okay,
Rick
okay.
talk to that.
Okay.
From
A governing
181,
council. Mhm,
non-stock corporation can definitely have a meeting over the phone or like this.
mhm.
Rick, do you want to talk to that now?
Sure,
or
I'll
later?
talk to, what was the first one? You can't communicate by email. So
Right, like an email chain, you can't do like the
email
reply all, like where like, I send out an email to the whole board and then somebody replies to the whole board, and because it's no longer public then.
Right,
That's what I
right.
had
Well, that's
heard.
the issue
Mhm.
is, Dave's talking from a 181 non-stock corporation perspective, but if you're
Mhm.
talking from an open meetings law perspective,
Right.
which charter schools are usually subject to the open meetings law, meetings require notice.
Right.
Meetings require usually 24-hour notice.
Mm-hmm.
And so, and meetings usually require that you all be present in a forum where the public can watch you meet.
Sure. Mm-hmm.
So if you're communicating by email
Mm-hmm.
and that meeting isn't noticed,
Mm-hmm.
then the public doesn't have the ability to watch what you're doing. So then that becomes essentially a meeting where you're, everybody.
It's like a closed session.
Right, where you're essentially meeting, but it's not, it's not noticed and it's not in public. So, so you want to avoid communications by email in that respect.
Mm-hmm.
The other question with virtual attendance, a lot of times we get questions about people attending by, I can't make the meeting, but I want to attend by virtual.
Well, like we do Zoom.
Right, exactly. So, the problem with that, I mean, there's some debate as to whether you can have that attendance because, if there's documents to be shared or something like that, then sometimes the person who's appearing usually by phone, if they're appearing by phone, then you can't see the person's reaction to certain things or they don't have access to documents.
Yeah.
So then the public arguably loses out on that interaction.
Yeah.
There's sometimes an ability to appear virtually, but again, usually would like to have everybody in person for those.
I'm actually zooming into my governing council meeting tonight.
Okay.
And we do that frequently because I live over an hour away now from my school. And so I video conference in and we share all of the documents virtually and we can even screen share and they can see me just like this.
Right.
And they can hear me and we post the Zoom login on our agenda, so that it becomes public to anyone who wants to log in that way.
Yeah, so then it becomes less of an issue because it's virtually like you're there, right? So
Yeah.
So.
Yeah,
But you do have a physical space where you are meeting as a
There
group?
is, yeah. We meet at the school, so someone at least is always there. Generally, the majority of the board is there, and it's just one or two people who Zoom in. But
And
otherwise,
and as long as the public can see Sarah, and and see Sarah's reaction, and the issue is if an issue comes up during the meeting and Sarah's appearing by phone, people can't see Sarah roll her eyes or throw up her hand.
No, I just shut off my camera when I roll my eyes.
And then the public loses that element of public participation. So
Okay. So it is legal to do the video in, as far as you're concerned, for sure, and as far as the open meeting stuff, as long as you still have the public presence, because I think there's a number of schools who have,
Certainly
taken
the virtual
advantage of.
schools do it.
Right.
Mhm.
The
Oh,
virtual
sure.
schools have their governance boards all over, I know.
And like up where Todd lives, their district is like 200 miles wide. So, in the middle of winter, if they're having a night governing board meeting, of course, some people are going to want to Zoom in if that's an option. So,
and if you're doing it by phone, I think that's a problem. But if
Phone
you're
is
doing
a
it
problem.
virtually,
Okay.
then it
Mhm.
becomes less of an issue.
yeah, that's
And like
interesting.
anything else, I think in what's legal and what isn't legal, I think you find the more factors you have that make it more open to the public,
Sure.
the less risky it is.
Yeah.
So it's one of those things. Is there a black and white? And every situation is different in how people set it up. But keeping in mind that the purpose is so that the public can come and see it. If you have those avenues, you certainly are at least covering that part of it.
Yeah. Okay. Great. Thank you.
Yeah.
Sorry to interrupt.
Well,
your
we're waiting
flow.
for the test case, so maybe you guys will.
Oh, there you go. So when we get sued, we'll know
Right,
who to
right.
call.
Actually, Rick, if you want to, so the next thing on my outline is unanimous written consent. So normally when I'm talking to nonprofit boards, we would talk about unanimous written consent and that being something that we would do. And just so we know what unanimous written consent is, if there's something everybody on the board agrees, this is a good idea, we want to do it, but we don't want to get together, we don't need another meeting. Why don't we just draft a document with the resolution, we'll all sign it, and we're done. Now, we would do that at, say, a foundation, But I think Rick would tell me, Dave, don't do that here because we've got open meetings.
I was gonna say but then how does the public know? Okay.
Right, exactly.
Yeah.
So you've come to an agreement before the meeting and then you all get together to sign it.
Mhm.
You know, you could notice the signing, I suppose, but then the public loses the element before that of,
Discussion.
a discussion about the issue. So, I mean, under the open meetings law, that would pose a problem.
Right.
Interesting.
So let's talk a little bit about notice of meetings, just so we've got that out on the table. If you're having a regular meeting, of course, that's been noticed a long time ago. We were meeting on a regular schedule. We know what's going on. You get your agendas out, your packages out. If it's a special meeting, you're supposed to be giving out at least 2 days notice. And if there's on the agenda, if removal of a director is on the agenda, we should be giving 7 days notice. And if it's something that would require a member vote, if you had members, and that's things like merging or selling the assets in sort of an organic change, then you need that 7 days notice too.
So generally a week's notice.
Yeah, is a good idea. If you just,
Okay.
and I think it's fair to give people a week anyway, but it's not always possible. And then who can call a meeting? Well, the president of the board, of course, can call the meeting, or enough directors that equal 20% of the board. So if you've got 9 people on the board, if you got 2 directors calling that meeting, that's going to be enough. Directors certainly can waive notice. So if for whatever reason you've got an emergency meeting and you can't get notice out in a timely manner, if the directors come, by showing up to the meeting, they're waiving notice, unless that director objects to notice and then doesn't participate in the vote that's going to follow. And that brings us to the idea of quorum. So if you've got a 9-person board, we need 5 people there to have a quorum. We need a majority. And then once we've got 5 people, if we're trying to get a majority vote, we're going to need 3 people of the 5 to vote for that item. And then this is the whole question is, what's the action of the board? Well, to get an action out of the board, we've got to first have a quorum, got to have enough people, and then we've got to have enough people of the quorum voting for that issue. The board can delegate to committees, and Chapter 181 is a little strange in the sense that there is right in the statute, embedded in the statute, there's language that says on each committee you've got to have 3 board members. And here's where we have a direct collision with open meetings law and what the statute says. Because I think, and I'm not going to put words in Rick's mouth, but he'd probably tell me that's not really such a good idea depending on how many people you have on your board. Because if that turns out to be, if you've got a 5-person board, that's a majority. And maybe you're having a board meeting when those people get together.
Quorum.
But I'll let Rick talk about that because that's really his area.
Yeah, well, anytime you form a committee and have even a committee that's less than the 5 members, if it's a subunit of the board or a designated committee of the board, that's going to be subject to open meetings law. So even when you have committees that are smaller than, if you have a 9-member board, even if you have a 3-member committee, if the board has identified that as the negotiations committee or the policy committee, that's still going to be subject to the open meetings law, which require the notice, which require actual meetings. So
are you recommending not to do committees?
I'm not recommending not to do committees. I think committees are just part of work because you need to break down the group into a smaller group and maybe bring some people in from the outside to get things done. I think you want to be very careful about how many directors are on each committee. So you don't inadvertently create a board meeting when you don't mean to, and then be very careful about how you communicate within those committees. But no, I don't think you can do the work you need to do without committees. I don't know how you could.
So maybe don't call them committees, but have a meet with one director maybe meets with a group of parents, and there's sort of a quasi committee working on some issue or working on some project, and that would be okay because it wouldn't be an open meetings
Sure.
requirement.
I don't
Well,
Like
no,
you could do
you
a
still-
project meeting or something.
It depends upon if you've got, it depends upon how that's formed. So if it's the board saying, you know what, let's form a committee to determine how to integrate technology into the charter school. And you call that the technology committee. And Sue, you're going to be on it, and Jimmy, you're going to be on it. And so you got Sue and Jimmy, two board members on the committee, and then everybody else is parents or something like that. Even if you don't call it the committee, if you call it the technology if they're coming back and making a recommendation to the board, that's going to be a committee that's subject to the open meetings law.
Okay.
So.
Oftentimes our governing councils end up doing things like events and fundraisers and bake sales and things like that they wouldn't be reporting back to the board.
Right, or wouldn't be making a recommendation.
Yeah, or like we had a committee to organize scholarship opportunities for our kids because ours were, qualified for different scholarships than the traditional kids. And so like somebody to, pull all that together, they weren't going to ever come back to the board. They were just like doing work. So that might be different.
That might be different.
Yeah.
So it's,
And so let me
very fact dependent.
let me ask you this then, and which might be helpful to them.
You're not allowed to ask.
Yeah.
So in terms of committees and hearing what they're talking about, so in order to remedy that and make sure that they're complying with it, is it enough that they just put a notice out to the public that they're going to be holding a committee meeting
Yes.
on a particular matter?
Yes.
So it really isn't too onerous of a burden in terms of what you have to do. Just keep in mind that when you're holding formal committee meetings, you may have to notice them up.
Correct.
So it's just something to always keep in mind. I don't think it's necessarily a don't have these committees, but more appropriately, just make sure you have the process in place. Would you agree?
No, I completely agree.
Okay.
Yeah.
Thank you.
Can I ask one more silly out of place question? What if all of the board members happen to be at like graduation? Like they're all in one place at the same time. If they're not making any decisions, is that how you?
Yeah,
away with
usually
it?
that's just kind of a chance encounter is
Okay.
what it usually is called under the open meetings law, or if they're just attending an event, but they're not going to be talking about
Like any business?
then
Okay.
but as soon as they start talking business, then it becomes a problem. But if
Okay.
everybody's just sitting there at graduation, but if three of them or four of them get together in a room and say, oh, yeah, and by the way, what do you think about that one issue? Then it's going to be a problem. So.
Okay. Good deal.
Okay, let's shift gears a little bit. One of the things that directors should be worried about, so when you're on the board, is the possibility of a conflict of interest. A director certainly could find himself or herself at conflict on a certain issue with the board in general. That conflict could come from a business that the director is somehow related to or owns, and that business has a contract with the school district or with the school board. Could come in a number of other ways, but it's possible you could have, or it could be relatives, whatever. If there is what would be a conflict of interest, that contract has to be, let me say it in the positive. The relationship or the conflict of interest has to be disclosed, or it has to be known to the directors. And once it is disclosed or known to the directors, the contract has to be fair and reasonable. And if those things are true, then that contract is going to be fine. If those things are not true, we've got a contract that's voidable and could be voided by the board at any time. So if you come into that situation, you just want to stop, make notice. And I think it's just a good idea, if you have business interests in the community, to make it clear what they are, make sure everybody knows, and full disclosure on all that kind of stuff.
Would they put that in some sort of a document or minutes of one of the initial meetings?
I think it's a good idea to record that in the minutes, that so-and-so, that Dave owns whatever.
Right.
I've got a landscaping business, and I may be hired to do the parking lots or whatever,
Right.
something like that. Yeah, it's just a good idea. And I think you want. And the other thing, of course, when we're looking for directors for the charter school, generally we want people who are a part of the community, who are who are out there, who can raise the awareness in the community of the charter school, and let's be honest, who can help in doing some fundraising. And those people are often local business owners. And so because those are the kind of people we're looking for, we just want to make sure that we make them sensitive to the fact that, while they know they're offering a good deal, we got to have full disclosure so we just keep this above board. Okay. Oh, I should note that the interested directors are counted at that board meeting for whether or not we've got a quorum, but they shouldn't be voting. And that makes it, if you think about the math on that, it makes it a little harder to get a majority, because you're counting them as one of the 9, but then they can't vote. So you've only got 8 then that can vote.
Can I toss in another
interesting.
caveat? Pardon me?
Oh, I just said I never knew that. We always just said we have like 7 and then those other people are here. Like the principal and the board member would come, but we never included them in our count of directors or of members.
No, he's just talking about ones who have a conflict.
Oh, no, if there's
You
a,
include them in their
so you're
count.
only
Okay.
You would
counting,
not include those.
Okay.
you're only counting directors, but you could have a director with a conflict.
Got it.
Yeah.
Okay, thank you.
I just wanted to clarify something in terms of quorum. A lot of the charter schools we work with have a number of, they may have a couple of teachers or on their board. And what has happened sometimes is that you end up with some of the traditional directors are absent from a meeting, and what your majority of the quorum consists of school district personnel. So that's something that a lot of people tend to overlook. And
That's a big, can I jump in for
Absolutely,
1 second here? I see
yeah.
that a lot with charter schools. And when I am helping a charter school put their governance board together and set up their non-stock and work on their contracts, one of the things DPI, one of their sort of flat out rules when you're working with them is you can't have any school board members on your governance board, because obviously you can't contract with yourself. You can't have the two. The more difficult question comes in is when you have a principal or when you have the administrator or when you have teachers. They suggest not putting teachers and people who are actually employees of the district on their governance boards for that exact reason. Charter schools do it anyway. I will counsel that, and they want to have a couple of people because oftentimes those teachers are the ones who perhaps started it. So they want to say in it, or may also be a parent or something along those lines. But I would say if you are in the process of starting your school, keep in mind that you really want to have heavy non-district employees for that reason.
absolutely.
Yeah,
Well-
that's a really good point.
It's so hard to do in a small town though.
It is.
So hard.
And if you're talking regular school boards,
No.
if you were talking regular school boards, okay, and you had a teacher on your school board, that would be what's called an incompatibility of offices. So that would be illegal. So, you can't simultaneously hold a board position and a teacher position because it's incompatible, because you're making decisions and people can't tell whose interests you're acting in. So if you're talking regular boards, that's
Not even
flat out
Right.
Well-
not possible.
Right.
So
In the charter school, we've had a situation where we had a charter school and a district come to head and we're negotiating back and forth under their contract. So as you start to think about it, one of the people on the charter school board was the district administrator. Well, the district administrator is an employee of the district. So now I can't have any conversations with the charter school board and keep any attorney-client privilege because he's a member of the school district and employed by the school district. So he has to step off the board for us even to have any conversations. So it really, the possibility of just all getting mired, particularly when you get to that spot where sometimes you do have them at odds and you have to make decisions of how you're going to negotiate between the two entities with the contract.
Right.
So it's a great point you bring up. I wish more charter schools were aware of that. I think that's one of the things is people are planning and setting their charter school governance boards that is overlooked.
Yeah.
Right.
I think so often it's a case of that there just aren't bodies. Like there isn't anybody, you know. I mean, Arena, I'm sure can feel this, and probably, yeah, Joel and all of us were, you know, small town charter schools where the only people who even know what a charter school is are the 3 teachers who are starting the school. You know, I mean, it's so not on anyone's radar. They, you know, you really are starting from nothing when you're trying to go out and like talk to your community and talk to your parents about, well, you sit on this board, you know, they don't know why or what's going on. And it's a difficult, you know, position.
One of the things that when I was at the department, my colleague Margaret and I used to disagree, where she would advise people not to have a teacher on the governance council. I was just the opposite in that. In Wisconsin, it is the whole charter school law is so tilted to the power of the school district that you need somebody that's inside, at least from the student vantage point, that has really been involved in starting the charter school, and that can, even though it gets kind of testy sometimes, some of these teachers do take on the administration in terms of their passion.
It is an odd relationship between the board. And we get the questions, I get the questions all the time as to really who has power for this, or who has, is this really our funds? And do we have, and Wisconsin
Hiring
has,
power is such a foggy.
and it really what it comes down to is, and we'll talk about that in a minute, but is what have you contracted for? You know, how have you developed your contract, and what have you put in there to give yourselves as a charter governance board authority and autonomy? But it is really difficult under the statute because the statutory scheme is just so mired in the two organizations, and really not a very clear delineation is between what powers are here and what are there. And I agree, it's been a tough thing for schools.
I had so many conversations with my administrator who was really supportive, but also, you know, wanted to play devil's advocate and make sure he was doing all of his job well. And, you know, he would say, yeah, it says in your contract that you have this right, but also there's this other law that I'm trying to uphold, or this other policy that's in direct conflict. And so he's like, what do we do? You know, like, we just have to pick one. But I mean, I can't think of an example. One will come to me, but you know, it'll be like that I have control over whether or not I want to suspend a kid when it like clearly says somewhere else in district policy that I have to suspend a kid if they do X, Y, and Z. But then I was waived that, but then he's also our principal. And like, you know, it was just this constant back and forth of like, we have no idea what the right answer is, so we're just going to make it up, you know?
Right.
But the problem that can really arise with a teacher on the board is, you know, what happens if that teacher is not performing well, or you know, something happens where the teacher, you know, does some act that, you know, leads to his or her termination. Well, then you've got that teacher voting on his or her own employment because they're both a board member and a teacher. Then what happens?
Can't
So,
they
you
The
know,
just
charter
step
board, though,
down
is
or-
not going to have the authority to fire the person. That is up the line.
But they would have the authority to
Council of the district.
recommend
They
it.
have a recommendation.
And so couldn't the board just request, like the board president would just say, we need you to step out of the room? Or,
they would say, why would I step out of the room? I'm a board member.
yeah, I don't know.
So,
I think
That's
it's a
something
conflict.
probably
Man,
should
you're
be
you're
included in the bylaws or in the contract that
if
any
personnel
personnel
discussion,
issues,
yeah.
yeah.
If personnel discussion is on the agenda, period, it would require someone to step out. I don't know.
And also
That's it, yeah.
that you don't
Makes sense.
give up too much power and control to the school district. What I've oftentimes suggested is that the teachers of that charter school select their representative that goes on the board, instead of it being appointed by the principal or the superintendent or whomever.
Oh, and see, usually when we set up the bylaws, we have it that it's elected by, that the group that comes together to set up the charter school then elects other board members.
Okay.
So we don't, I've never seen it as an appointment process, but that's interesting. I didn't know they did that.
Oh, yeah. Oh, yes.
Okay.
Yep.
Are you talking an appointee, the school board rep, like, liaison?
Superintendent would be, and the principal would say, select the teacher. If there's a
Oh, the
teacher
teacher
representative.
representative.
Yeah.
Okay, okay.
I've seen that happen numerous times.
Did we have somebody new jump on, or is that just, I'm trying to count. Oh, that's me, Todd, and Sue. Okay, I'm good now.
Okay.
Did Jackson get on?
I haven't seen anybody new.
Okay.
Okay.
So I think now we've got the concept that board members can have liability. And so you could have, as a board member, a liability for what's called an unlawful distribution. Well, what's an unlawful distribution? Could come from a conflict of interest, could come from a distribution of cash that the entity just simply doesn't have that's going to put it into a bankruptcy situation, or anything else that would be, quote, unlawful. And so if I'm a director and I've voted for something that turns out to be an unlawful distribution, I'm going to have personal liability for that. And we'll talk about some things that provide some protection to board members after that. But the proceeding has to be brought within 2 years of the vote. So if we just sort of put that aside for now, and we'll come back to those liability concerns. But those are real concerns for charter school board members. Officers, pretty simple thing. You're going to simply have a president, a secretary, and a treasurer under the statute, unless you say otherwise in your corporate documents, and you'll have every other position that you want to have in your corporate documents. And you can have officers resign. Same process as a director. And of course, the board can remove any officer, president, secretary, at any time for a majority vote generally, or unless there's some other vote required by the corporate documents. Now, let's come back to that liability issue. If I'm a director, I can rely on people who have expertise in certain areas, and I've got no reason to believe that that person doesn't have that expertise. So if I'm voting on the use of funds, and I have from my accountant and the CPA for the charter school and everybody else financial information that shows that that's okay, we've got the money to do it, it's fine, then I can rely on that, and that's going to take me out of personal responsibility. But if I've got some reason to know that those people don't know what they're talking about, then that's not going to be any protection for me. And so as a board member, you're able to rely on, it's reasonable reliance. You think of it that way. You can rely on what you're told by the employees so long as, and your advisors, so long as you've got no reason not to believe them, and what they're telling you is inside their area of expertise. In general, limited liability protection for the directors and officers. If we look at it, how could you be liable for a breach? You could be liable if, for some reason, you voted for something and that was a willful failure not to deal fairly with the corporation or the charter board. So that's an intent to deceive. That's pretty easy. If you've got a violation of criminal law involved in whatever this conduct is, that seems relatively easy too. There's an improper personal benefit. Again, we're talking about a conflict of interest or willful misconduct. So if it's not any of those things, and I'm the director, I'm going to be not subject to liability in that situation. But of course, anyone can sue anyone for anything at any time, and we can't stop lawsuits. So then at the end of the outline here, you see there's indemnification for directors and officers. If they are sued, they defend that suit and they win on the merits. And so if that happens, the charter school board is to reimburse me for my costs for my legal defense, essentially my attorney's fees. And so that's supposed to provide indemnification. Even though I was never in the wrong, I've still got expenses. And so I think in general, as we think about the governance of charter schools, if we keep in mind that we've got one entity, the school district with a school board, we've got another entity that's generally a non-stock corporation that is governed by a board of its own. And with this legal framework that we just talked about, where we're going to find that the rubber meets the road a lot, I think, is in that charter contract. And Tess is going to talk about the charter contract.
Okay, so before we go on to the specifics in the outline that I provided, just to go back for a second and talk, and I know that Joel, you're in the planning phase, and I think Carrie and Courtney, you are a little bit further down the road than that and already operating the school. It's never really too late to go back and look, and certainly not for you, Joel, and definitely not for you either. When you are looking at the charter school and the governance board, you really do want to think about it as its own little corporation. And you want to make sure that you have your corporate documents in place. So your articles of incorporation, they're really easy to file with DFI, but if you're going to go on and you're going to seek tax exempt status as a 501c3, there are certain provisions you're going to want to have in those articles of incorporation that DFI will not require. So you can file it and you can have DFI accept it and you can become a non-stock, but you are going to be missing the specific provisions in there that you need later on then, unless you know what they are and you've made sure that you have those in there for filing. With respect to bylaws, there's no magic to bylaws as to what goes into a bylaw. Under the statutes, what happens is if it's not covered in your bylaw, it will default back to the statutory provisions. But when you're putting together your bylaws, you really want to think through how you want this corporation or your organization run. How do you want to elect directors? How do you want to remove them? How do you want to run meetings? How often do you want to have meetings? How are you going to notice them up? Are you going to have members? You know, Dave talked about that. Membership is a tough thing. A lot of schools that I've seen didn't even realize they were creating a membership organization, and now you've given a group of individuals, usually the parents of a child who has a student at your school, this ability to vote on issues, but you're really not doing a great job as to keeping the master list. Who are your members? Do you have the requisite number of members there for a vote? Are you getting the notices out that you're supposed to? So when we talk about, we would advise not having a membership organization almost more out of convenience and ease and just running an organization of not having to try to always have an updated list of what turns out to be somewhat of a transient population of people because their kids are in and out or they're moving in and out of the district. And it's a lot of work to have to do that. So when you're putting together these documents, keep it in mind that you don't want simple and easy. You really want to take some time and think through how you want this to be set up so that those answers are there for you when you are coming to these issues and you're looking at them. That is no exception with respect to the charter contract. And I assume Carrie and Courtney, you guys probably already have a charter contract in place. Joel, do you have your charter contract? Are you in the process of doing that?
I'm in the process of reviewing some other ones and trying to pull ours together. I think our goal is to kind of take some others and revise those and pick out the things that we want and make it into our own.
Okay, so I'll talk about the charter contract then. When sort of the overriding theme of the charter contract is it's a contract between the district and this governance board, this independent board. The power that you have in terms of what the charter school can do in operating the charter school comes from that contract. So, under the statutory scheme really only provides you so much. You have authority to be exempt from certain statutes and some of the provisions with respect to days and hours and times in a seat and things like that. But really what your powers are when you're talking about an instrumentality of the district are defined by this contract. So remember, it's like any other contract. You are going to want to take some time and either negotiate provisions or really think through of what sort of powers and autonomy as a governance board you want in your school. So when you're looking at the charter school, you know, you have an authorizer, and I won't spend a lot of time on this part of my outline, but you have an authorization procedure where the school board can authorize a charter school. The board awards a contract to a person under the statute. Well, a person can be a whole number of people, usually a group who've come together to plan the charter school and ultimately, you know, develop this governance board. The charter school isn't operated by the district administration or the board in theory. And I know that, you know, you talk about how much control you have over it. The purpose of the charter school law really was to allow autonomy in these charter governance boards to set curriculum and decide how much time they're going to be in school, how much time you're going to be out of school. What are your days going to look like? Are you going to be in school in you know, the bricks and mortar type building? Are you going to be, you know, there's provisions for virtual charter schools. Are you going to be more hands-on in the community? That the whole statutory scheme is to give you that kind of control. In exchange, the board does retain, the school board does retain quite a bit of oversight, because as the authorizer, they have quite a bit of power. I mean, ultimately, they can shut you down under the statutes. So they have the ability to make sure that you're meeting academic goals, so that you're meeting state statutes in terms of you can't go out and start buying religious materials with the funds that you get, because they're your fiscal agent for all the federal grant money that comes through. They have sort of an administrative oversight. And I'll give you an example of where that comes in. We had a situation where the charter school was doing some things that DPI wasn't particularly happy with. And DPI's first go-to is not the charter school. Well, it is, but ultimately the buck sort of stops at the district. So the district was having to then move in and really put pressure on the charter school in terms of and use its oversight to make sure that, you know, religious materials weren't being purchased, that they were following the statutes in terms of instruction. So it's a weird kind of mix between the two, but the district board does have quite a bit of oversight. So they have some roles in there. The charter contract, and this will go to you, Joel, when you're talking about it. Attached to my outline, you will see, and I don't know if you have this document, Joel, but their DPI has a charter reviewer benchmark document.
Yep.
And if you look on the back of that, that will go through all the different things that DPI will be looking for in your charter contract. The statute has 16 different provisions in it that are required in your contract. You have to address them. And when you look at my outline on page 4, you'll see those provisions. And I'll spend some time, I'll go through them, but I won't spend a lot of time on all of them. You need to have the name of the person seeking to establish the charter school. That's your governance board or your group. You have to figure out who's going to be in charge of the school. Is it going to be the district administrator that's going to be doing, you know, most of the day-to-day in charge of the school? Is there a lead teacher? However your school is working. A description of the educational program of the school. You really want to put this in place, and I've watched charter schools kind of plunk something down in these charter contracts, and then later on they're morphing or they're developing a little bit more into something a little bit different, and the district is saying, wait a minute, that's not in your charter contract. We didn't know you were going to try to be a STEM school. We didn't know you were going to try to do this sort of thing. So you really want to also think through, you know, what does your educational program look like? Does it follow a particular philosophy or method of teaching? Is it a personalized learning type plan? Is it, you know, program based? What sort of program and school are you putting together? So really take some time in developing that.
I have a
The
quick question
methods.
about that.
Sure.
How do you find the right balance there? Because we want to have, like, there's a lot of things that we want to do, but we're not, I don't think we're going to be able to do all those things in our first year. So how do we put the right amount where we have, like, we want to be able to do all these things, but we don't want to have them saying, well, you said you were going to do this and this and this, and you're not doing it yet. Is there a way to, like, is it better to put more in there and not necessarily get to all of it? Or is it better to have less and add?
Well, let me ask you this. The things that you're going to do, could they potentially be fit within the rubric that you're describing as it is currently now? So what your sort of educational program looks like now, are those just going to be kind of natural extensions from it, or are those going to be completely different educational programs?
We're switching our programs quite a bit. I mean, we're going to project-based learning. We're a traditional school currently. So we are going to go to project-based learning. We're going to have multi-age classrooms, but we've already instituted that this year, even though we're not a charter school yet. But we have some other things in there, like we want to go away from using grades and do badge learning, but we're not going to be ready to do that next year already. I mean, I think that's something that's got to be developed as we get project-based learning under our belt and we understand that, then we can begin to develop the badges and move in that way.
Okay. I don't think there's any pat answer to what your question is. And I guess if I were going to advise on how to do it in your contract, I would talk about where your school is starting and where you hope to see it developing, sort of including but not limited to type language. When we are lawyers, we always use that sort of language to make sure that we aren't limiting ourselves, but we're not specifying, but you're kind of opening it all up. This is the direction you may see your school going, including but not limited to project-based learning, alternate grading systems, things like that. I guess I would leave yourself open to that in there. So you certainly can mention it without having to put sort of a four corners on it all, but indicate that that's what's coming down the pipe.
Don't you have to include something with like your 5-year goals or like what where you
you have to have
students will be performing? You could maybe lay out sort of your 5-year plan in there too with that language.
You have to provide in there, and that's one of the methods that you'll use to do both the state educational goals and also the methods you'll use to measure the goals and expectations. So those could be fluid. I mean, they may change, but you're going to want to put in there some specifics with the idea that, if you're going to plan on changing your grading systems, I would suggest at least mentioning that in there, that's down the road that you're, looking toward different.
I've seen some schools also put that sort of thing in their own handbook, charter handbook. So in your case, Joel, where you're looking out maybe 2 or 3 years, if you feel safe or confident, you could create some sort of a rubric that indicates this is where we're starting year 1, year 2, year 3, and at least give yourselves the flexibility to phase all of that in. But at the same time, you're putting up a set of standards that the board can measure. The school board can measure your progress.
Okay, that sounds good.
Makes sense?
Yep.
Okay. So the number 6 is the governance structure of the school. You need to have that in there. And just what we're talking about, how is that governance board going to be structured? How are you going to, one of the big things that, they'll look for is how are you going to have parent and community involvement in there? Are you going to recruit members? Do you have a certain number of board members that have to come from your community or are parents of the school? Those are the sorts of things that you're going to want to address with that. The qualifications that have to be met by the individuals to be employed by the school. You're going to want to be specific if there are specific qualifications. You're definitely going to want to put in there that you will meet all DPI required qualifications. And remember, when you have things like virtual charter schools and charter school teachers, it's pretty specific in the statutes as to the teacher licensing requirements for those. And you want to make sure that in your charter contract, you indicate that you will abide by those. The procedures the school will follow to ensure the health and safety of the pupils, do you have emergency plans, things like that. The means by which the school will achieve a racial and ethnic balance among its pupils that's reflective of the school district population. This is a tough one. I'm never quite sure what to advise school districts on the exact language. There's not any real guidance other than your charter school, they want it to look like your community. So to the extent that you can make efforts and indicate in there that you're going to make efforts to have your population of your charter school reflective of your greater community, I think that's what they'll be looking for in there.
If I could interject something.
Yeah, please do.
In my tenure, there have been several charter schools that have been challenged by some community folks for not having an equal distribution, roughly equal distribution of low
income.
free and reduced lunch. Low
Excuse
income.
me.
And as you would expect, usually when you're talking about something innovative, the people that are going to be at the front of the line are going to be people that are in the know, they read, they understand what's going on in the field of education, and they're going to tend to be your middle class, upper middle class folks.
Agreed.
So what we've advised when I was at the department is that you put a plan in place that you're actually going to seek out in a special sort of way, sharing information with free and reduced lunch or poverty families, so that you go that extra mile. You don't just leave it up to your general advertising or marketing effort, because a lot of these people are working 2 or 3 jobs, and they may not have internet access. So that's something that I think it's important that the district and the charter school go that extra mile to find.
I agree. And I think OCR, which is the Office of Civil Rights, is focusing heavily right now on charter schools and both their work with special needs students as well as minorities. So definitely something that you want to keep track of in terms of your efforts with respect to both of those. Because I think OCR is really, with the explosion of charter schools, I think also comes quite a bit of scrutiny. And public school districts are and have been dealing with these issues for quite some time, but now the focus is sort of turning to charter schools because that has not been much of an issue up until now. Did you want to talk on that at all?
No.
Okay. The requirements for admission to the school, it's a public school. Keep that in mind. The charter school is a public school, but you may be a high school. So anybody in grades 7 to 9, the general requirements for admission. The manner in which your annual audits of the financial and programmatic operations of the school will be performed. Generally speaking, often in most of the contracts that I see, your audit procedure will follow the district's audit procedure, that you will use the district's auditor. The procedure for disciplining pupils, and you were talking about that earlier. The procedure, most of the time, frankly, in the contracts that I have seen, districts have been pretty set on having charter schools using their disciplinary pathways and their disciplinary procedures and policies with respect to, for one thing, because there are kids, their expulsion process, the gun laws and all the different laws that they have to do mandatory discipline. Generally speaking, follows it. On the flip side, and on the alternate side of it as well, is that discipline has been a big topic of OCR as well, and sort of the discrimination that goes into discipline for various students. So the district, I suspect, probably is going to want to have a pretty good handle on how kids are being disciplined across the board in the charter school.
That, if I could interject,
Yeah.
that's an area that has gotten rather touchy in the last 2 or 3 years. When it comes, in terms of following expulsion and suspension and stuff, that's right on target. But when you get to the next layer down, where DPI is really pushing PBIS, and districts sort of assume that they have to do it throughout the district, which they're imposing, but what oftentimes happens is charter schools go through another, like, responsive classroom training in terms of a specific model for handling behavior.
Like an RTI type model?
Yeah.
Somewhat like that.
More personalized,
more
and
personalized.
if more democratic sort of, they'll circle up and there's one model called restorative justice, where you talk through, okay, what was the situation? How does it affect the community? How can we make it right? Rather than just saying oh, you're expelled, or here's a gold star because you did a good thing. It's not black and white. It's much more of a process, and a lot of the smaller schools are finding success in that and really want that to be their community rather than the PBIS. And so they're having trouble. Yeah, they're having trouble getting away from those district requirements because of all the legal things now.
And also because of the politics of it. If you've got 4 elementary schools and one of them wants to do restorative justice or
responsive
classroom, and all the other elementary schools are being forced to do PBIS. Now that puts a superintendent in a tough position. The conflict between.
And then there's some, they'll say, okay, well, you can do restorative justice, but you also have to do PBIS, which is completely hypocritical. You can't really do both. And so
that is what really gets in the way.
Yeah, they're innovation. Well, you have to do what we say, but okay, if you want to do your thing too, that's fine, but it doesn't work that way.
Sound familiar, Aces?
Okay, the public school alternatives for pupils who reside in the school district and do not wish to attend. A description of the school facilities and the types and limits of liability insurance the school will carry. the effect of the establishment on the liability of the school district, all these things you're going to see in your contract.
And actually, one that you just sort of listed, I think both of these districts, like Joel, is yours a conversion too? Like you're converting?
Yep.
Yeah, so both of them will have to have really clear language about the kids who are in their attendance area
And
who
where
don't
and what
want to go to
options
the
they'll have
conversion.
to go someplace else.
And are you both clear on how that's phrased in your contracts, or is that something that you need to talk about?
Yeah, well, we're working on the whole enrollment piece and getting that written out. But basically, our thought and idea is that anybody who's currently attending is automatically gonna, like, they'll have first priority because we have
Okay.
under our enrollment cap right now. And then once those kids fit the seats, anybody else who tries to come in and wants to enroll, they'll enter a lottery system. And yeah, I know I probably will have some more questions as we get farther down the road. Because one of the things our district, we're doing a charter school as part of the purpose is to try and bring more kids into our district. So we're trying to find a way to be careful where we're not turning away kids that are in our own district, like that attend one of our elementary schools that want to be here, but we also want to bring in students from outside that maybe aren't attending here.
Let me ask you this, Joe. When you're talking about converting, you're converting a school. Are there other it's an elementary school?
Yes, it's one of 3 elementary schools. It's a rural outlying elementary school, and we have 3 of them.
But there'll be there are non-charter schools in your district, is what you're saying? Also,
Correct.
besides
So we
you, so
would
it's not like
provide-
a district that completely goes charter.
Right.
Okay.
There are other elementary schools in their district, but they're turning their whole like elementary attendance area charter. So a kid who lives in Kewaskum and wants to go to a non-charter, they're going to have to bus to the next small town. Or, I mean, or are you in
So
Campbellsport?
Kewaskum is our district. That's like the central
Right.
place. We're in a little town of Wayne. There's a bar and a church.
Okay.
That's about it. And the school.
So those kids are going to have to go to the next little town
Yeah, we'll
Can I-
bus.
can I
If they
jump in
wanna-
here? Can I jump in
if they
here?
want non-charter.
There's a provision in the law that if the student's if the students live in your attendance area and the parents don't want them to go to the charter school, then the district is responsible for providing transportation to one of your other in-district elementary schools. Now, we might as well address the part of your lottery issue, Joel, and that is if you want out-of-district students, open enrolled, in other words, so sort of the cash cow. Obviously, that's a tough situation in that if you have some local parents that didn't get in because of open enrollees, now you are not serving people who you are really set up to serve as a priority. So what we oftentimes suggest is that you have 2 enrollment deadlines. One in like January or February, preferably January, and the open enrollment period then starts in February. So you would have already advertised, marketed, distributed information to everyone in your district and set a deadline of January for anybody in the district that wants to enroll in the charter school. Everybody after that then is the selection process is contingent on whether or not you have met your numbers. If you have met your numbers and you have you have excess applicants, that's when you hold a lottery, and it would be just those kids after January, including the open enrollees, that would be in the lottery pool.
Okay.
How does that, and I haven't looked at this question, how does that figure with the open enrollment law and their lottery now?
You can't accept open enrollment kids until after May 1st.
Right?
So that's why you want to
But you have to give your preferences first. So if
Right.
you have to at least give a preference to those in your attendance area.
You don't have to. You don't have to. You could just wait until May 15th. Everybody that applies gets pulled out of the lottery. So if you have a whole bunch of out-of-district enrollees that are going to get priority just by the fact that they're selected out of the lottery, you have given no consideration to your local population.
Right.
So that's why we suggest having, if you want to give your local population a bit of a preference, then you set two enrollment deadlines. One in January before the open enrollment starts, and then one after the open enrollment ends.
Okay. So, yeah, that's good input. You set, Joel, with that?
For now, yeah, I'm sure I'll come up with more questions.
Overwhelmed, maybe.
Right, yeah.
Can't have it both ways, dude.
Yeah.
So then let's talk about the instrumentality or non-instrumentality. I'm assuming you guys are all instrumentalities of your district. I won't even chat about that. The other provisions to consider in your charter contract, the length of the charter contract, which may be up to 5 years with the opportunity for renewal, the conditions under which the charter will be renewed or revoked by the board, including the conditions under which the board will intervene in the school operation if it fails to meet contractual obligations. This whole revocation process really is an area that I think gets short shrift in contracts, certainly from the perspective of the charter school. I think that when you are looking and putting together the charter contract, make sure that you have and you've really looked at what your provisions are for revocation in terms of, do you have a time to cure? Do you know who is the person who decides if you've cured it? When would the charter school end if the district decides that they're going to go revocation? Does it end at the end of that academic semester? Do they give you to the end of that full academic school year? Make sure that you have in place those revocation procedures. Now, the statute gives the charter school authority to revoke a charter contract in certain situations, and I'm going to pull over here. If it violated its contract, you failed to make sufficient progress, you failed to comply with generally accepted accounting standards of fiscal management, you know, if you've not followed fiscal management type policies, or if you violated state charter school law. So you want to just make sure that you're going to have an opportunity to cure if the district is coming to you and saying you have violated one of these things, that you have particular notices in place, that you have timelines in place for curing, and that a process is in place for deciding if in fact you have cured it. So unfortunately, I actually have been involved in a couple of those, which has been eye-opening when all of a sudden now you are looking at this contract that I think a lot of people write the contract and it goes away and they never look at it again. Well, all of a sudden when you're in a battle with your school district, that's where you go to, and you are following now those provisions in the contract. And at the time, I know the charter school and the district, both that we worked with, were thinking, boy, we should have spent more time thinking through this process, because it was a little unclear as to exactly what had to go on.
I think in the last few years, I've seen finally more contracts that, number one, have that provision, but also have a provision that the charter school board
Can revoke.
it. And
Yes.
that's, I mean, the law is really written to the advantage of the school district.
Absolutely.
I mean, there's just no doubt about it.
Mm-hmm.
And one, if I could just make a comment
Sure.
here. Joel?
Yep.
You are sitting in probably the most critical position representing both the school district and the charter board. You are representing the district and putting together a contract. And yet, as this whole thing goes forward, I presume, and I think I know you well enough, you are enlightening, building enthusiasm on the part of staff, on the part of the governance council, to really take control of this school. And for them to do that, you're going to have to be able to hand off a lot of that authority that you right now hold almost 100%. You have in the past, and now you're going to hand it off. Now that may or may not, I think it probably will be okay with your upper management people, but that is probably the biggest challenge that I see in charter schools is guys in your position put this together, and then when you actually go to activate and implement it, you still operate very much like you did in the past. Where I think, philosophically, I think you're right on target. You want to empower your people to take more control of the school and encourage the community to be involved, et cetera. So that's, I guess I just wanted to point that out, that you're in a real important critical position.
Mm-hmm. and developing this. And to your point, in terms of making sure that the charter school, that the governance board also has the rights in the contract to revoke. I've seen provisions in there that say if you lose your ability, you lose your right to make curricular choices that you want to make. If the district, if they default in any of their terms or conditions or promises in the contract, you have the right to revoke. So you want to have provisions in there also, and exactly what you're pointing out, which is a great point, that protect the charter school as well, with respect to, because the statute only has provisions with respect to the authorizer or the school district.
There's a provision that I have seen create more problems than anything else, and this goes back a number of years. And there's a school that's been in operation now for 7 years, and in their contract, they had a provision that the teachers would be involved in selecting the new teachers, or that they would make recommendations for replacing teachers. And the second year, the district just placed a teacher in the charter school, and they had not put in place any process or procedure. It said that they would be involved. Well, what does that mean?
Yeah.
And that's where it comes down to putting this sort of process and procedure in place in some sort of a handbook, that everyone knows what the rules of the game are. Because after you get down the road a little bit, you're going to tend to revert, especially, Joel, if you were to leave, your successor is probably going to be just following the district's routine personnel process. Mm-hmm. And you want to set that aside, because if you want to retain some sort of an innovative school, the focus of the energy and the innovation has got to be incorporated in the staff and in the charter board. So if you leave, you still have a core of innovation remaining.
I need to move my car.
Oh.
I would go one step further, and I would say, rather than just have it in a handbook, I'd have it in your contract of how that hiring process is going to go.
Good point.
I would have whether or not you have that they make recommendations to the board. The board, as its employer, is going to have the ultimate oversight or the ultimate decision as to the hiring. But I would put in place where your charter school input comes in and what process is to be followed each time you're going to hire staff.
And who's going to be involved in the actual selection process, how many teachers, a board representative.
Yep.
Are you going to, you want to avoid the personnel office giving you 3 candidates and you select one of the 3.
Right.
You want to have the opportunity to actually review the credentials, interview people, and then make the recommendation.
Mm-hmm. And I would also have that same procedure in your charter contract as to how you evaluate your teachers and who evaluates them and who's the recommendation in terms of both them staying and being retained and both letting go. So I would, in the charter contract, when you're talking about employees and hiring and personnel, I would be very specific. And I would include in there the things that you want. Keep in mind, and I think a handbook is a great idea, but keep in mind that your legal binding document is the contract. So unless you somehow attach that handbook to the contract that says, the contract says all provisions in the handbook also are subject to this contract, I think you want to make sure that it's in here.
And that I think that perhaps the best way to do that is to go through your school board policy handbook. Identify all of those policies that you want waived and or changed. In this case, it would be the employment procedures. And then you want waivers from that, and then you indicate what that process will be under your waived option.
Right, because you're going to want to include that in your contract as to what, I think we talked about it, as to what district policies you want to be exempt from. Now that might take some negotiation back and forth with your district. All of this probably will and should, frankly. There should be some real dialogue as to what's in this contract and how you're going to work it and what sort of autonomy you're going to have and how these processes are going to be put in place. So, okay, so that said, I have covered most of the things in the contract. I think probably more than that was even in my outline. So I will move it along now to Rick, who is going to talk about, which I know is a question for charter schools and districts alike, which is charter schools and public records and maintaining records and things.
Yeah, so my talk is divided basically into 3 different parts. And the first part deals with just kind of whether the public records law applies to charter schools. I think there's been some question, but that's kind of been resolved by a recent case in 2008, but we'll get to that. The second part is just an overview of the public records law, talking about the public policy behind it. And then the third part is just a step-by-step procedure on how to deal with certain public records requests. My outline is fairly long. It's like 15 pages, but I don't plan on going into it in any detail. I'll just probably highlight some parts of it, and and then we can leave a little bit of room for questions here as well. But the first part of the outline kind of talks about who falls under the public records law. And the general definition of who falls under the public records law is an authority. And that definition is kind of laid out in page 1 of the outline. And normally dealing with school districts, it's an automatic that they're automatically subject to the public records law. There's been some question as to whether charter schools are subject to the public records law. But in order for them to fall under the public records law, usually they have to fall under the definition of quasi-governmental corporation under the definition of authority. And there was a recent case in 2008 dealing with the Beaver Dam Economic Development Corporation that kind of laid out a test to see whether the Beaver Dam Economic Development Corporation was subject to the public records law. And based on that test, or prior to that, we didn't really have any tests, but based on that test, now we've kind of come to the conclusion that charter schools generally are subject to the public records law. So there's a 5-part test basically on the bottom of page 3. And it includes the tests set forth by the Supreme Court in that Beaver Dam case. It includes non-exclusive factors that they look at. And the non-exclusive factors, which usually means that they can look at other factors in order to come to a conclusion. But in that Beaver Dam case, the question was whether this Economic Development Corporation was subject to the public records law and the open meetings law. The court, applying these factors found on the bottom of page 3, came to the conclusion that this corporation was subject both to open meetings law and the public records law under the definition of this quasi-governmental corporation. And these factors that they applied, whether the corporation serves a public purpose, whether it received public funding, whether the positions on the board of directors are reserved for governmental employees, whether the government employees serve as officers of the corporation, and to the extent that the corporation is housed in governmental offices, uses governmental equipment, staffed by governmental employees. So, these are non-exclusive factors. They could ignore some factors and, look at other factors as well in order to come to their conclusion. But, I think the primary factor is whether the corporation really serves a public purpose. And I think by and large, we've come to the conclusion over the last several years that yes, based on these factors, charter schools generally are subject to the open records law. So, and even if they're not subject to the open records law, there is a provision under the open records law that says contractors of people who are subject to the contractors of an authority. So you're a contractor of the school district is an authority. Even if your charter school is not subject to the public records law, if you're a contractor of an authority, then the records that are created or produced or collected as part of that contract are going to be subject to the open records law if a request is made to the school district. So sometimes requests will be made directly to the school district for charter school documents, while you can expect that the school district is going to contact you for whatever documents they're seeking. minutes of meetings perhaps, and you're going to have an obligation to produce those as part of that contract. So even if you're not subject to the open records law, but we think you are, you're still going to have an obligation as a contractor to produce records to the school district if they receive a request.
Could I interject?
Sure.
Based on some experience we've had just recently with a charter board down near Milwaukee, we really advise people to be as transparent as possible, and including doing little things like posting your minutes, like you're saying, posting your minutes on your website within X number of days of your meeting, and that just becomes, just displaying the fact that you are wide open, you're not hiding anything. It probably wouldn't be too much of a problem in Kewaskum, but Waukesha it can be, or other places similar to that.
Yeah, I mean, a lot of school districts have gone to board docs or other software where the agendas are posted, the minutes are posted right away. So, I don't know if you have those particular software, but I think even if you have a website, you can easily post them usually to the website. So.
And you still have to post them in person, right? At like the courthouse or the school office, school district office or something like that.
Yeah, there's no real requirement to post your meetings or post your minutes.
Not the minutes, but
the meeting notice. Usually, you have to post that to different places. Yeah. So on page 5, just an overview of the public records law. The records law is designed for access to actual records. It's not designed to, require you to provide information to just general questions. So this is access to records. So if you're creating a record, you're creating minutes, that's what they have access to. It doesn't mean you have to create records specially for, hey, I want to know why you made a certain decision about not enrolling my child. Well, we don't necessarily have to answer that question. You want to for political reasons probably, but you don't have to necessarily answer that question. But they could say, well, I want all the records related to your decision as to who to accept for the school district. And then you have to go back and see whether you have records that are responsive to that request. And those may involve student records, which we'll get into, but there may be reasons not to disclose those. But my point is that this is access to records rather than access to information. So, and the public policy is, one of the main public policies is that the public should be entitled, as I was saying, transparency, the greatest possible information related to the affairs of the charter school. So this means, if someone makes a request for emails for a certain period of time for the board's communications, they're not necessarily entitled to emails related to your personal accounts or not accounts, but your personal emails. If you send an email to your sister about, getting together that weekend for the Badger game or something like that, that's not necessarily something that's going to be subject to the public records law. It's only items that are related to governmental affairs or charter school affairs. One particular item that even school districts sometimes don't have is the public notice. And this is a specific policy identifying who your records custodian is, where people can request records, how much you're going to charge for records, who your local public officials within your charter school are. There's certain requirements under the law. You have to have a public notice identifying this so people know how they can request records from the charter school. So that's a particular requirement under the law. On page 6, I identified a couple of different resources. The Attorney General Office, who's the main the Department of Justice is the main entity or agency that enforces the public records law. So they have a good website and a good outline for you to go to in order to identify exactly what the legal requirements are. And they also have good presentations on their website as well. They have different PowerPoints and presentations that you can view online on the Attorney General's website. Also, if you go to the newspaper's website, which is, they formed this corporation or organization called the Freedom of Information Council, which is essentially the newspaper's organization. So they want everything transparent. So they have a good website identifying different legal requirements from their perspective, which is sometimes different than the government's perspective. So I often go there to see what their perspective is as well.
What was that resource?
It's on page 6 of my outline. So you can go to page 6 of the outline. There's, yeah, okay.
Thank
So
you.
it identifies the Attorney General's website and also the Freedom of Information Council website. And then I laid out on page 6 a couple of initial considerations. One of those considerations, again, is that the public is not entitled to, and it's specifically laid out by the Attorney General, that they're not entitled to answers to specific questions. What they're entitled to are records. So when they make requests, they should, you should identify what the request says and whether it's asking for records or whether it's simply asking for information. Part 3 of the outline is just going through and analyzing once you get a public records request. So it takes you through kind of a step-by-step analysis of, okay, I've received the request, now what do I do? So starting with the first step, usually you identify who the records custodian is. Sometimes the request comes in and we have a teacher dealing with the request. You don't necessarily want that, okay? You want to get that request to the proper authority within the charter school in order for that person to deal with the records request. You don't want someone just randomly handing out records without, someone who's been designated the records custodian knowing what records are going out.
Who would you recommend that is?
Usually it's like the principal,
Okay.
or, usually not necessarily the board members, but
Okay.
because it's, usually it's the principal within the school, that is kind of the one person that is designated as the records custodian.
Okay.
So.
Yeah, I think in the contract, you have to designate who the management person is, or the position.
Yeah.
And sometimes it's the principal, sometimes the director of instruction or something like that.
Right.
Teacher.
And if that person's out, usually they just designate, it's usually the principal or designee.
Right.
So if that person's out, then you just identify someone who's going to handle it. The next step is just identifying the manner and time limits of a required response. There's no specific timeline in which you have to respond to requests. It's just as soon as practicable and without delay is the time. Usually the Department of Justice says usual turnaround time is about 10 days. So 10 business days. So you should factor that into, if you're taking longer than that, it's beyond what the Attorney General recommends. Analyze the request and gather all documents within the scope of the request. Sometimes the issue comes up as to, okay, well, they've requested all documents without identifying what the timeline is. I want all minutes of board meetings without identifying the scope of the request. Well, is that within the last year? Is that just the last meeting? Sometimes you just want to have a communication back saying, okay, well, what are you asking for? But, sometimes it's so broad that you can't even identify it. And the records law would say, okay, the response or the request is not reasonable in scope, and you can deny it if it's not reasonable in scope.
Do you have advice on what types of things would people request you know, I mean, just so like planning ahead, sort of like knowing, you know, I mean, you should be keeping records, obviously, of like your minutes and agendas and budget reports, election process.
Student records, all your
Oh,
student
student
records.
records. Oh, yeah.
That's
Okay.
really, I mean, that's the big one.
Okay.
I mean,
Okay.
That's the biggest.
Yeah, so the next step is determine what's a record. So
Yeah,
the record
right.
can be, and it's defined on, you know, on page 8, but it's defined very broadly to include anything that is kept or maintained by the district, to include videos, electronic documents. So if you've got a Twitter account or if you've got a Facebook account for the charter school,
Mhm.
those documents could be subject to open records requests. If you've got budgets and people are concerned that you're not spending the money properly, they can request copies of the budget. Minutes of meetings, student records, employment records. I'm dissatisfied with this teacher. I'd really like to see his or her evaluations for the last 3 years. And so, you know, some of these records may not be subject to disclosure because there's certain laws, student records law, employment records laws that we would say, okay, well, on balance, we can't disclose those either because they're confidential in terms of student records law, or just on balance, we don't want to disclose a teacher's evaluation. So, but it is fairly broad. And, you know, we get a lot of questions related to, you know, the new thing is the technology. You know, everybody's got Google Docs now, everybody's got documents in the cloud, and, you know, what sort of documents are subject to disclosure and what sort of documents. So.
Sorry.
No, it's okay. So that becomes an issue. But there are certain documents that are not subject to disclosure, and those are your notes, your personal notes. If you're just keeping notes on a particular student or something like that, if you're a teacher, that's not going to be subject. Draft documents, if you just got a draft of the budget and it's still in a work in progress, that's not going to be subject to disclosure. Personal documents, you know, if you back and forth between different colleagues that just talk about, okay, where are we, you know, going to get a drink after work,
Okay.
you know, that sort of document is not going to be subject to disclosure. So because it's personal in nature. But yeah, the scope can be fairly
Huge,
broad,
yeah.
and people ask for everything under the sun, especially when you know, things aren't going well. So
Right.
What about exchanges between teachers and regarding a student, or teacher school psychologist regarding a student? Is that open?
that's a record, but it's a record related to a student. So it is a record identified as a record under the public records law, but we would say you can't disclose that document because it relates to a particular student. And so in some cases, we would say, okay, can we redact that record and redact, you know, names out of the record to remove all the students' names? But sometimes it's still identifiable to a particular student or students
Just based on the
that we
situation.
would just say, forget it, we're not going to disclose it.
And is there, and I don't remember, I thought this might be the case, is there case law that came out that talks about the fact that unless that email was intended to be part of the student record file, that it's not considered a record? It's like if you're just like writing to another teacher in the school and venting about this student and you didn't intend to be part of their documented file. Is there a case law out there that talks about that? I can't remember. I thought I had seen something. That maybe
I've heard people take that position, but I don't take that position.
Okay.
I think that, you know, I think you're going to get in trouble with that. And,
That's good to know.
you know, the Department of Education has a separate family policy compliance office. And I think they're fairly vigilant about making sure that these records get in the hands of parents if they request it.
That's good to know because I had questions about that.
Or stay out of the hands of the newspaper if they can.
Right.
So.
Okay.
And then that brings us to the next step: determine whether the records are subject to disclosure. So even if they are records within the within the scope of public records, they still may be not subject to disclosure because they may be student records or may have some other basis on which not to disclose them. So I won't go into a lot of the exceptions. But on page, page 11, you determine whether to charge for fees within these. There are certain fees that you can charge for certain requests. You can charge for copying costs. You can charge for location costs. And sometimes this can be kind of a strategic decision, because sometimes if people don't want to necessarily pay for these documents and it's going to take a long time to locate whatever they're asking for, you can say, okay, well, this may take some time and may involve some costs. I can do that for you, but it's going to involve some costs, and then that may make them.
Where do you specify your time and cost?
Usually in the response, usually you have to put it in the notice, the notice that you prepare. You have to identify that you know how much you're going to be charged for copying, how much you're going to be charging for location. Usually it's just the per hour time that someone would take to locate.
So you have a form that says like open records request form, and that's where it says.
Sometimes, but you don't have to have a form. Even someone that writes in and says, I want copies of all budget for the last 10 years, and you say, well, okay, well, that's going to take some time for me to locate. Then I just write back and say, we estimate that it'll take 4 hours to do at, however much the hourly rate is, $20 an hour. So therefore it may take $80 for us to produce these records. Do you still want us to go through with it? And then at that point in time, but you can only charge for location costs if it's over $50. So that's the one qualifier there.
Can I ask a quick question
Sure.
of these guys? When charter schools are setting up, and I just would be interested, if they're not in the location of the school, like for example, Exploration Academy in Verona is right actually in the high school building.
That's most of them.
Okay, so, but then we have ones like, and Core Knowledge, I guess, is too, but New Century isn't exactly, for example, like within Sugar Creek's building, or our Chinese immersion school or something like that. Do the charter schools set up then record retention in terms of student records, student grades? Does it look similar to what the district does with its, or do they, and I know that in contracts I've been asked, when can the district come over and review our records? Who's allowed to do it? Do they have to ask advance notice? Things like that.
We did, my building was off-site, and we kept our own like short-term records, but then when a student graduates, we sent like the permanent transcript over to the district, and they kept it in their like fire safe or whatever. And that way, say 10 years from now, like if our school didn't exist anymore, or if all of our staff had turned over, because we're such a small school, that way the district had their long-term filing system where they have all those like papers printed off that they could get a kid a transcript.
And like the student identified, records, like identifiable records of like a student's grades or health records that you might have. Are the employees trained to know that those are kept in certain ways and can be disclosed with only certain releases? And
They should be.
Okay.
I would say not exactly. I would say like I spent, some time with our district secretary, and she kind of showed me, okay, make sure you have this form, and this form. And I just kept a filing cabinet that was locked, and, it wasn't anything super formal, but you're right. I think that they ought to be.
It's really, really complicated in that districts themselves oftentimes don't even consider that until after the school is
Right.
open.
Well, that's what I wondered.
Where you run into issues is when a school is going to use competency-based grading, where they're going to have student competencies are going to get graded rather than on a traditional transcript. It may or may not interface with the student management system, which is also becomes an issue.
That's been a huge issue.
It's a huge one. And again, one of the things that really tramples on innovation is that you have to do all of this, most of the stuff that everyone else does in addition to your.
Right. I talked to Beth Lewis a long time about the competency.
Yeah.
Grading.
You have to
figure out.
fit it all in, and it's really complicated. Like we end up doing what we're doing and then like backwards translating it to fit into their system, so that it's like, oh yeah, my kids learn biology, like never mind that it was this big complicated project that took a year, and like, you know, yes, okay, fine, we checked off your boxes, so I have to like spend all that time going backwards to make their report, you know, their digital report, like look similar to what a traditional one looks like, even though in reality we didn't really do all the same, you know, coursework and stuff. And
See, I was hoping that someplace before we end that I want to
yeah,
make
we
a
should
point
wrap it up soon.
to particularly to Joel. This is the sort of thing that oftentimes never gets discussed until after the school is open. And that's why it is so critical for people in Joel's position to make sure that everybody up the chain of command, including the school board, is getting a regular update on what's going on and where the issues are. I have seen innumerable superintendents meet with the school board a couple of times before applying for the grant, tell them that they got the grant, and then not really keep them updated until the contract comes in, and then everybody freaks out about, well, what's this autonomy stuff?
Mm-hmm.
And then the superintendent has to start pushing back on the governance council to weaken the contract. It happens a lot.
And I just, in terms of listening to you, I'm thinking, oh my gosh, when I talk to some of these boards, I suspect some have never heard the stuff that you're saying.
Oh,
In terms
absolutely.
of records and maintaining them and all.
The one thing that we had always heard,
Great training.
and I don't know the truth to it, is that like if you get these council members like Courtney and Carrie, that like they are, you know, they're a parent, they don't have a district email address, and so then when you start sending out those agendas every month, they go to their personal email address, and then all of a sudden their you know, public information is being sent and exchanged via that email, so their personal email address or computer could be subject to open records. Is that true? Like, where is that line drawn?
That's absolutely true, because it's not really looking at the account, whether it's on personal account or whether it's on a charter school account, it's whether it relates to governmental business.
Right.
And so if this relates to charter school business, then it's a record that falls under the public records law, regardless of whether it's on their personal account.
Do a lot of board members, Rick, get separate just board member accounts like through the school, so that anything that's sent that's all that's in that account?
Typically, yes.
That's what we
Yes.
recommend now, that your school, you can talk to your IT person in the district and give them the names. But I mean, it's sort of a chore because like you have turnover every year. So then you have to be submitting these new names, and then the council members have to remember to check that account, which is really difficult. If you say, oh, we need to call a special meeting, then you almost like need to email them at their personal account just to get their attention to say, okay, go check your other account. Like it, you know, I don't know. It's
Another
complicated.
interesting gateway that we have to get through is, and it's really frustrating to me, that we don't have more board members on here today. But all of the advertising and marketing that we did, almost all of it goes through a principal, business manager, superintendent, who obviously can act as a gateway to distributing any of this information out to the governance council members.
Now we are recording this session, Barry, so
That's-
I didn't want to
mean, that's-
stop you there,
That's-
because hopefully we are going to get it out to.
But that's a
some
reality.
government
I mean,
It
that's a
is. No,
reality.
I agree. Everybody I emailed was a district employee.
Yeah.
And most of the people on our newsletter list who get my advertising and stuff are district employees. So it's true.
And it's
Yeah.
it's not only emails, and the bigger problem becomes, you know, getting the emails from the board member who doesn't want to produce those emails because they're on their personal account. Then the school is basically, you know,
Right.
up a creek because they can't get to those, even though someone's requested it. And then you may have a lawsuit saying that the charter school failed to produce
Right.
this records, and because you've got this one board member who refuses to produce them.
Right.
but it's not only email, but it could be text. It could be
Right.
text on your personal
yeah.
cell phone. So,
Yeah.
if those relate to governmental business, then arguably those are subject to the public records laws.
That's something that we don't talk about.
Yeah, we've gotten requests for phone numbers on, I want a list of all phone numbers based on this, and that was a school issued cell phone.
Yeah,
But
but not
so they-
very many people do
Right,
that.
right, but still, if they've got phone numbers that they've called, and sometimes you got to put a balancing test in there too. Okay, do we want all these numbers disclosed? Because some of those numbers could be, numbers that aren't listed. So do they want those disclosed? So,
Right.
but the text messages are.
That's interesting. I need to just pause this for a second. Whoever drove here, you may need to move your car. It's been 2 hours, and I know
I
you're
did.
only staying for. Oh, you
did.
did. Okay,
did.
perfect. And then also, we only have about 5 minutes left formally of the meeting. I don't know if you need to wrap right at 11, or if any of our attendees do, but we need to be wrapping up. And I have a phone meeting actually at 11 too, so I'm just going to step in the other room. But do you have finishing thoughts on your outline
No,
first?
I mean, and
Okay.
just the last page of the outline talks about enforcement, so you need to be aware of that. I mean, either someone who has been denied access to records can bring an enforcement action, and can ask for attorney's fees, which we all know can get fairly high. So,
Thankfully.
those
Yeah.
those pesky attorneys,
Yeah.
or the district attorney or attorney general can bring an action as well. So,
Oh, interesting.
the enforcement mechanism is out there.
Okay. And then I guess final thoughts or questions from the attendees.
I don't have any final thoughts, but thanks for listening.
Any
Joel,
questions?
Carrie, Courtney, you have things you were hoping to get and we didn't get to?
I guess just one thing I would, if you get, Tess, if you have any charter school contracts that you think are pretty thorough, that I could peruse or look through, I think that'd be great.
Okay.
Have we sent you some, Joel?
I have a few, yes.
As a matter of fact, I think I sent some to you, didn't I?
Heather might have asked you, but I think Heather sent me some.
Okay.
And I did some review of contracts for some districts through ISN as well.
Yeah.
So,
Okay. Well, thank you guys for the outlines.
Thank you.
I think are great. I'm going to use those keep going back to those and review those as my guides as I move ahead.
good luck.
Yeah.
Yeah,
Thanks,
good luck.
folks.
Carrie, Courtney, anything?
No, I have no further questions.
All right, and then Sue jumped on to remind me that Carrie, Courtney, and Joel, if you could fill out the survey link that I send you just for some feedback or any thoughts on this session, just, whenever you get a chance today, before you forget probably, that would be fantastic.
Will do.
Okay,
Sounds good. Will do.
thanks.
Thank you.
Thank you guys for
Yeah.
We didn't have enough people.
Yeah, thank you so very much, you guys. This was absolutely fantastic and extremely informative.
Good. Great.
Thank you.
Great, have a good day, everyone.